Okay, we're now on the record. Today's date is October 29, 2024. We're here in the matter of 8224 Philadelphia Road, LLC. This is a public deliberation, and that is case number 24-024. And with me, of course, are Fred Lauer and Brian Pennington, who also presided over the hearing that we had in this matter. This is an de novo appeal from a decision of the Baltimore County Department of Public Works regarding a sewer bill of approximately $29,000, which was lodged against the property at 8224 Philadelphia Road, which is owned by Charles Lamassa. So there's one legal matter, I guess, preliminarily, and that has to do with the motion that was filed to reopen the hearing and also to issue a subpoena to the county for records associated with any true-up that may have occurred. That is, any accommodation between Baltimore County and Baltimore City for non-wastewater, I guess, that may have been transmitted by Baltimore County's system through the Baltimore City wastewater facility. And also associated with that is a request to, associated with the reopening request is to present a copy of the 1974 agreement between the city and the county regarding the treatment of wastewater. Treatment, I don't mean treatment in the scientific term, but the handling of and billing for wastewater between the city and the county. So I have to say, I'm not exactly sure whether this is a decision that rests with me or whether this is something which a legal decision of this sort should be decided by the panel. I would prefer to be conservative and throw it open to the panel. I can tell you that my view is that I would deny the motion. I think there's no basis to reopen this matter. The 1974 agreement, we had indicated to council that they could refer to the 1974 agreement in their memo, and counsel for Philadelphia Road did in fact do that. It's essentially it's for all intents and purposes a matter of public record, and whether it's formally introduced as an exhibit or not, it's been discussed in the memos, and at least from my own part, I've taken it into account in terms of my ultimate sense of what should happen here in terms of the deliberations. But in terms of reopening the matter, I think there's no basis for that. The true-up information, frankly, is, I think, just irrelevant. And I can't, there's no basis to prolong this matter and have more hearings or have another hearing with witnesses to discuss something which is so, I think, profoundly peripheral in my own view. So I also don't think that any of this merits a subpoena to the county. I certainly don't think we should, in this matter anyway, purport to decide disclosure under the Maryland Public Information Act. So I, you know, in order for a case to be reopened, it requires something that's not just ordinary. I mean, we don't do that. That's not done as a matter of business routine by courts and judicial bodies. Requires really something rather special. And I think there's nothing special or extraordinary or even out of the ordinary about these issues. So my own view would be that the motion should be denied, and for the reasons that I said. Mr. Lauer, Mr. Pennington?
No, I agree completely with you, Mr. Chairman. I think you have pretty much outlined a position that's very similar to mine. I really couldn't add anything else. I agree that we should not reopen the case, and I don't think the 1974 agreement would really add much to this whole matter.
Yeah, and to the extent it adds anything, it's there.
Yeah,
we can look at it.
yes, we can.
Yeah.
So that's all I have. I mean, I don't have anything else.
I agree. I agree with both of you. I mean, the agreement's there. It's referenced. It's referenced by the. I mean, it's referenced in the case in chief and the testimony by the county, and it's also obviously it was provided. So, and it's referenced in the memo. So,
Right.
I agree.
Okay. So so the motion is denied for the reasons that we have all articulated. So let's move on then to the substance of the matter. Again, I'm happy to begin. I would find in favor of the county on this. You know, it's an interesting question, I suppose. About what happens when cooling water is put into the wastewater system. But for me, I mean, there's a number of factors, but two overwhelming and controlling issues for me is frankly the testimony from Mr. Hallman, because he said two things. First of all, he said cooling water isn't necessarily pure. Okay? So we don't even have a record in this case by which we could say that the cooling water at issue was in fact free of contaminants. And we can't even say that. We don't know. The burden of proof on that, I think, well, I mean, we just don't know. And so I would think that the burden of proof would be on the appellant, would be on Philadelphia Road to make that showing. I can't imagine that the county in every case is required to negate something which may or may not even be an issue. So in the absence of any evidence that this was actually pure water, I don't see how we could make such a finding that it was pure water. That's point number one. And point number two is, again, Mr. Hallman testified that there is no way to distinguish what is put into the sewer system by a user in Baltimore County as it comes to Baltimore City. I mean, there just is no way to do that. you know, there are some mechanisms set up. Mr. Lamassa points out there's some ways of dealing with what happens when we know that cooling water is wrongfully disposed of, but that doesn't mean that that doesn't, I mean, you know, that doesn't mean that it is not accountable in the regular normal course of affairs if it's wrong, if it's disposed of as it was in this case in the sewer system. The county, I mean, what happens when you turn the tap on in your sink to get, you know, to wait for the hot water to come on, and you let it run for 30 seconds and there's cold water going down your drain? That's pure water. We can't account for that. I mean, there's no meter that measures whether the water that is going down your drain is contaminated or not. And the county can't measure that for its individual users. And the city can't measure that in terms of all that stuff that gets pumped into the treatment facility. So, you know, I suppose it's possible in a situation that there could, you know, if we really knew for sure what was going on, maybe the county and the city would reach some kind of true up or some kind of accommodation if it was much. You know, we're also talking about an infinitesimal amount of water here in the grand scheme of things. I mean, it's a lot to Mr. Lamassa, we get that, and it's expensive for Mr. Lamassa, we get that. But in terms of the volume of affluent that the county ships to the city in the sewer system, I mean, this is well, I mean, this is a bead of sweat on a fly. I mean, you know, this is too small to even register on any kind of metric anywhere. So even if it were possible to do, which it is not. So so that's my view. I mean, I could elaborate, I suppose, on various features of it, but the bottom line for me is that I would affirm, no, it's not affirm, I would find that the property owner is responsible for the payment of for the sewer charges associated with this leak or this malfunction. It's really not a leak, it's a malfunction of his own equipment. It's his tenant's equipment, but it's attributable to him. So, comments?
I agree with you, and my thought is, even if we had evidence that it was pure water, pure, clean, the cleanest water in the world that was going in there, it's commingled with the other water.
Right.
So it isn't like there's a separate drain that goes all the way to the sewage disposal place for that.
Right.
It's commingled with the other waste on the way to the sewage disposal. So, even if we had evidence that it was completely purest water in the world that came out of there, it wouldn't make a difference to me. So the question is then, how do we? The meters seem to be in order from what we know, right? We don't have any evidence that it wasn't in order. There was clearly a malfunction in the refrigeration. I think in terms of the preponderance of the evidence in the matter, that the county proved that this amount of water, wastewater, went into the system during this period of time. And that's the proper charge for that amount of wastewater going into the system. It seems to me that there probably is some other alternative out there that this water could be used for, rain barrels, or it could be a lot of other things could be taken care of, and maybe is. And I'm not an engineer or scientist or environmental person that knows how to do that, but it seems to me that all of that could be shipped elsewhere and not in the sewer system. But I thought Mr. Lamassa did an excellent job in terms of preparing his case. I think his memorandum was very insightful in many ways about the history of the system. I don't, I just am not convinced that there's any other way to look at this other than to affirm, or as you will, or uphold, or the opinion of the Department of Public Works.
Mhm.
And I agree as well. I think the county met its burden in this case. Obviously, there was no evidence. There was no evidence presented that gave us any idea that the water wasn't going into the sewer. I mean, it's obvious all the water was coming from the water line, through the meter, through the HVAC, or the cooling unit, and right into the sewer line. And obviously, as you both said, as soon as it touches that sewer line, it's commingled. It's not clean water anymore. And I mean, I agree with both of you on that. I think the county, like I said, I think the county met their burden in this case. Water coming in, water going out. And that's exactly what it was. It was measured properly. There was no sign of any malfunction of the meters. And
Yeah.
the water is, I mean, there's no way you can differentiate between, just like both of you said, no way you can differentiate between clean cooling water and wastewater. I mean, it becomes wastewater as soon as it touches that line, in my opinion. And
Even if it is clean, even if it's clean.
Even if it's clean, it becomes
which we're
wastewater
not-
as soon as it touches
Which
that.
we can't necessarily say here.
Right. So I agree.
Well, Mr. Lauer, I agree with you on Mr. Lamassa's presentation. It was indeed excellent and thorough and well put together. And sometimes we're not blessed with zealous counsel in matters before us, but Mr. Lamassa has done himself proud here, and so I agree with that sentiment. So, okay, any further comments? No.
I don't have anything else. Thank you.
Okay, so me neither. So we will adjourn, but there's a unanimous decision that the county has carried its burden of proof and demonstrated that the charges in this case are appropriate. So we will issue an opinion shortly, and then if the appellant wishes to take a further appeal, he can do so pursuant to the circuit court, pursuant to the rules for an appeal from the Board of Appeals. All right.
All right. Thank you.
Okay. So we will adjourn. Thank you both very much. I appreciate it.
Thank you.
Have a great day.